Oh, you know, Nora, maybe you want to start with everyone so we can see who's here before you spotlight. Does that make sense? Nora, can you just put us on gallery view for until I'm done, and then you can spotlight the two magistrate judges?
So just choose gallery view in the top right of your screen there, Judge,
Oh, sorry.
and you should be all set.
I was only seeing Judge Allman, which is a delightful view, but
I was only seeing you.
oh,
Now I
Jesus.
got it.
All right, well, I can't switch it. My mouse is not working. There we go. Okay. Hey. It's just that I wanted to begin by just being able to put some faces with some names. We see your names all the time, and I don't think I think Steve once, but I haven't had a lot of folks appear before me to argue the way the magistrate judges have. So until we begin substantively, I thought it might be good to just be able to see everyone. Just at a show of hands, who represents claimants in Social Security? Just one? Just Steve? And who represents the commissioner? Okay. So a few things I want to say, and then I'm basically going to turn it over to the magistrate judges because it's clear that they, you know, as you can figure out, do 90 some odd % of the work on Social Security cases. And what I thought I wanted to start with is just to let you know that the court takes these cases very seriously. You know, they affect they affect real people's lives. They affect a government system that we all care about preserving the integrity of. So from both ends, we get it, and we also get the fact that it's incredibly personal, particularly to the claimant. And I want you to know that we've taken it very seriously. And toward that end, Frank Perry from the clerk's office went through and put together a list of things for me that we've done over the years to try, from an administrative point of view, to make them really deciding here. You know, to that end, we've added the magistrates, as you know, we've added the magistrates to the draw for the last 6 years. We've taken care of issues of privacy that was important to some of the claimants by just referring to first names and last initials. We've got acceptance of service agreement from Social Security Administration, which helps tremendously in the service end. We now have electronic filing of administrative record, which is one of the greatest of all time effects on, for us at least, on dealing with Social Security cases. And then just looking statistically, Frank put some numbers together. Last year, we had 50 Social Security cases filed here in the District of Rhode Island. Only 3 of those 50 were consented to magistrate judges. Now, compared to 2016, we had, so 6 years ago, we had 94 cases. So we went from 94 to 50. And at that time, we had 27 cases consented to. So we went from 30% of the cases consented to before the magistrate judge down to 6%. And maybe we can talk about that some, why that is, and what it is we could do to make our operation a little bit more efficient in that regard, and the judicial office decides it. So it really is our goal to try and streamline, to try and make efficient, to try and get to the heart of the issues that are here before us. And that's why we thought of CLE, where you heard some from us, and actually we were able to hear some from you about that might make it more effective and efficient for your clients. So with that, I'm going to introduce, as you know, the magistrate judges handle the majority of the Social Security cases. Judge Allman's been doing it for 15 years or so, maybe a little more.
Moore.
Judge Moore. Judge Sullivan's been doing it 10 years, just about. Yeah.
Only 10.
But only 10. So you're dealing with incredibly engaged, involved. I will tell you right now, they and their staff give these cases the seriousness which they deserve. And I hope through this, we'll figure out a way to come out of this where we're all more focused on the important issues, where we're more streamlined, we're more efficient at getting to the difficult issues that you present to us. So with that, I'm going to go off and let Judge Alman and Judge Sullivan speak to you.
Right. Well, I'll start off. I was appointed as a magistrate judge in 2004, so I've been wrestling with these important cases for quite a long time, and they are very important. And there's an individual behind each and every one of these cases. Just as a follow-up to some of the statistics that Judge McConnell brought up, we did have a fewer number filed last year than in prior years, but to date, I believe we're at least 15 or more filed in 2022. So I think our numbers are jumping back up, and I don't know if some of that is the reduction in past years was because of COVID delays in the Social Security system. But at 15, that puts us on a pace to be at 90 for the year, which is we've had more in prior years since I've been here, but that's a hefty amount of cases for us to adjudicate. And as Judge McConnell said, Judge Sullivan and I deal with the bulk of them. One of the things I thought I would start with is I over the years when I've been to presentations about advocacy and brief writing, etc., one of the things you hear about is know your audience. So I thought maybe I would share a few things about who we are and what we're dealing with when we get these cases. So first, we're both very busy, and we have two components to our jobs, one being the criminal parts of our job, which are fast and furious in the duties that we have. And then we have a number of duties on civil cases, which one part of, it's a significant part, but it's just one part of many aspects of our civil responsibilities are these Social Security cases. So we're busy and we're pulled in a number of directions. We are constrained by a limited standard of review in these cases, but we want to see that fairness and justice are done for these claimants and that any harmful errors are addressed and remedied on remand. We do have compassion for the individuals who are involved in these cases, and we want to know who they are. I often will read the record or read the briefs to understand who the person is who's behind this particular case. But frankly, we're not swayed by pleas of sympathy. Judge Sullivan and I deal with bail hearings, and we issue warrants and arrest warrants every day. So we're not going to be swayed by pleas of sympathy. So some of the briefs I see that have a lot of time spent trying to pull on our heartstrings, you're better off focusing on the record and what are the claimed errors, because that's not going to be persuasive to us. We are focused on the individual case before us. So as we open a Social Security case and start to look through the briefs and the record, we are focused on that case. But each of us are mindful of the impact of setting precedent. So if we were to rule for or against the claimant in a case, and we then have to write a decision and articulate reasons for that, and we're mindful that that's going to apply in future cases. So we have to be very careful about the reasoning that we set forth and the grounds for our actions. And to be frank, following up on the fact that we're busy and pulled in a number of different directions, we are always looking for efficiencies and shortcuts in how to deal with these cases. And if we get well done briefs that are accurate and concise um, frankly, we're more able to and more likely to cut and paste parts of those briefs if it's appropriate, or to look to those arguments to support our decision making. If the briefs are not concise and they're not to the point, it makes it more difficult for us to do that. And we'll get into some tips later on best practices with regard to briefs, and Judge Sullivan and I can give you each our thoughts on that. I think that would be helpful to you folks who are actually writing the briefs. But Judge Sullivan made a suggestion before we get on the Zoom that I think would be very helpful for you to hear from each of us, and she can start, but it might be helpful for you to understand how we approach a case when one percolates up on our calendar that's ripe for decision, what we do to get our arms around the issues and try to understand. So if you want to comment on that, Judge Sullivan, I think that would be of interest.
Absolutely. And just along the same theme, the focus on the case that's right in front of me, and I think all of us do it the same way. I on purpose don't want to know what's my score, how often do I go this way or that way, because I don't ever want to think, oh, I just affirmed 3 in a row, so I need to do something different here. I don't ever want that. I want to be absolutely laser focused on the human being who's sitting in front of me. I also think that our review of these cases, even though we have, the standard of review, we cannot let our heartstrings be the guide. We cannot decide the evidence. We've got to look for errors and see if they're errors. We nevertheless probably spend more time on one case than anybody during the administrative phase was able to do. And I feel conscious of that. So my practice is to begin, and that's why talking to you guys is really important, to begin with the briefs. The very first thing I do when I get a case, first of all, I load the record up so that it's accessible to me. Depending on its size, I might make it searchable. And then, but I don't take even a glance at it. I go right for the plaintiff's brief. And I map out, I read the plaintiff's brief, and if it's a well-done brief, when I'm done reading it, I have a list of the errors, the claimed errors. I've been able to identify the key documents that are pivotal, the opinions, with the pin sites to those opinions. To the extent that there's something that's really critical, I may jump into the record and just print it. If it's something I think I'm going to be reading like 15 times before I'm done with this case, I'll print it. I don't print much. Mostly I just work with the electronic record. I map the case, and if the plaintiff's brief is good enough to let me map the case, so I get a sense of the sequence of the case, including when did the state agency opinions get rendered. So I plug that date in so that as I'm later reading the record, I'm very conscious of what's the evidence that wasn't seen or was seen, but I'm really micro-focused on what's important. What is the lawyer for this individual telling me happened that in their view is a miscarriage of justice? Where are the errors? Then I read the government's brief. And I often, again, if it's well done, I then annotate the notes that I made from the plaintiff's brief with what the defendant has to say. And what I'm looking again to do is, what are the issues? Might there be a case that I now need to make sure I've got in my mind so I still haven't cracked the record, but I'm really outlining issues presented, key documents, key evidence, timeline. Now I go to the record. My practice, I don't know, I think I'm crazy. I read the whole record. I always read the record. When it's the 3,000 page records, I do sigh deeply, but I lay eyes on every page. Some pages I don't spend a lot of time on. Sometimes it's a bit of a phone book flip, but I read the whole record. that read of the record is informed by what I've just done. So if the briefs were good and the identification of issues was well done, or the commissioner's identification of why the issue is answered, either harmless or whatever, as I read the record, I've got all that in my mind and I'm ticking and tying and taking notes. When I get done reading the record, I generally feel as if, I mean, the comment that Judge Allman made a moment ago, I now know the case. I have a feel for the case and the claimant. Now I go back to the briefs, take a quick look. Now it's time for a deep dive into the ALJ. Read the ALJ's decision, and by this time, if it's going to be an easy one, I already know what I'm going to do. I try to write the decision as quickly as I can after I've been through this effort. The accuracy of the pin sites in the briefs is really, really important, really helpful. By the way, one of the things that slows us down, and I think on your side, having oral argument was a real problem, because you would be in front of me. I've just read the record. I got the whole thing in my head. I know exactly where I'm going. And I have a lawyer in front of me who doesn't even know where to begin to prepare. And I think those were uncomfortable. But what they allowed us to do as judges is to render decisions very, very quickly. Because after I write the decision, what is a relatively efficient process slows down, because now the decision has to be, under my practice, I have to have at least 2 law clerks read it, check every sentence, every pin site, and sometimes that can take a long time. Sometimes it can take weeks before a law clerk frees up from other tasks to get the opinion done. So one of our goals in doing the oral arguments, which has pretty much lapsed, was to, first of all, allow the lawyers to really crystallize the issues for us. And second, to get decisions done more efficiently. So we're struggling a little bit for how to sustain that efficiency, given that the consents are no longer coming. And if anybody had a suggestion for how we might be more efficient based on perhaps what you see in other jurisdictions, I'd be interested. But that's basically what I do. So the briefs are pretty darn important.
I mean, I do a similar review, although one twist is, I think what I do initially is read the ALJ's decision without being swayed by anything in the brief, so I can understand what he or she said out of the box. Then I look at the briefs, then I look at the critical documents in the record, the various medical opinions or records that are an issue, or the hearing transcript if there's something important there, etc. Judge Sullivan, you made some comments about when we were getting some consents and dealing with oral arguments, and back then the oral arguments were in person. If we moved forward and we received more consents, what would be your position regarding holding those kinds of arguments remotely rather than inconveniencing counsel on both sides to come to the courthouse for those proceedings?
I think that makes a ton of sense. I know that I've had counsel, I think there may be counsel on this call, who have asked to participate telephonically in an in-person hearing, which is clunky and I think not fair to the person on the phone. But using Zoom for civil oral arguments is something that I've found to be extremely effective. And then nobody has to travel and park and all of that time-consuming stuff. You can really dedicate the time to the hearing. So if that was something that counsel were interested in, I'm wholeheartedly in favor.
I recently did have a consent case where I held oral argument by Zoom, and it went, I thought, very well. And even if we get back, when we get back to in-person court proceedings, I think to the extent I'm allowed by the rules, I will schedule hearings by Zoom on these kinds of matters, because I know a lot of, on the defense side, the lawyers with the administration are mostly coming from out of town, and then the lawyers who are on the plaintiff side, some are from out of town, but many are also pulled in a lot of directions, having to go to hearings before the ALJs. And so I do think it would be more convenient for the litigators, but I would, if I'm wrong on that, I'd be happy to hear. Now, on the issue of consents, obviously, if you consent to adjudication of a case before Judge Sullivan or I, you give up your right to seek review of a report and recommendation by the district judges. And I know that might be an important issue to some of you, to not give up that chance to object. But the one thing I would say on that is I've been doing this now 17 years, and I've had, over all those 17 years, only a handful of report and recommendations that weren't adopted by the district judges on Social Security cases. And I would hazard to guess it's got to be much less than 5%, maybe even 2%. But I will say, in the period of time when I was regularly holding oral arguments on these matters, I would go into the hearings with an initial read on the case and an initial leaning of which way I was going. And frankly, I would say much more than that 2%. I would be regularly persuaded at those hearings by both the plaintiff side and the defense side to go in a different direction than I thought the case should go if I had just been handling it on the papers. And I think, frankly, on both sides, not consenting, the reason we hold the oral arguments on the consent cases, because it does give us an option if we feel it's appropriate to rule from the bench, which is more efficient for us. If it's not consented, we are required to do a written report and recommendation. So because of the time involved, we're unlikely to hold oral arguments on cases where we need to write a written decision anyway. So frankly, I think on both sides, it's a lost opportunity to not come in face to face with us at an oral argument or remotely on Zoom, if that's the way we go in the future. Because it gives you another bite at the apple with us to persuade us to go in your direction. I don't know if at this point it makes sense. I want to leave some time at the end for questions, because those are obviously important to us to hear from you practitioners. But at this point, Judge Sullivan, I thought maybe we'd pivot into what we think might be helpful on the brief writing side. And I don't know if you have some initial thoughts or tips that might be of interest to the practitioners.
Yes, I do. I think often we see or I get a sense that the plaintiff is trying to essentially relitigate the case, ask me to reweigh the evidence. And that is a extremely ineffective argument. It's frustrating because when I read an argument like that, I find myself reading the brief really closely, searching for an argument that actually is highlighting an error, because our job is to focus on error and not a de novo review of the evidence. So I think the first tip that I would give is, I think our scheduling order says identify the issues. And I don't think a lot of practitioners understand how important it is to not just say, oh, the the ALJ didn't have substantial evidence to support the RFC. And that's really not very helpful. But a clear, articulated summary of the issues to begin the brief is, I think, critically important. The second thing is to anchor why the errors mattered, why it's not harmless in the record, and to drill into actually citing to the places in the record so that I can be directed by the attorney to dive into the record, rather than if I see an argument that doesn't tell me where to go. I do try, I go, but I find my own way into the record, and it may not be helpful to you. Or worse yet, it may be that the commissioner is telling me where to look, and then the argument is going to fail. So my second tip is citations to the record are critical. And then here's one that may sound self-evident, but we're working with records that are thousands of pages. And there is nothing more frustrating than having a sentence that is pivotal to the outcome of the case. 20 pinpoint sites follow it. And I'm 10 pin sites in of reading the page and going, why is this page response? And they're just not the right pages. Maybe the page before. So then I look before and after. But when it gets to be a lot, at some point I begin to say, this is a brief writer who did not give me the pin sites that I need. And I may just give up and stop looking. I may go see if the other brief gives me accurate pin sites, and I'll follow those. So accurate pin sites to the record is absolutely critical. And 20 pin sites is not helpful if 3 will do, but the 3 ought to be absolutely critically accurate. I don't know how Judge Allman or Judge McConnell feel about it, but if you want to start citing cases, each of us have written a ton of cases. When I see a case that I wrote cited back to me, I know the work I did to do that case. I know I have a sort of a feel for the law as I worked on writing that opinion. So then when I get my own opinion, I can say, all right, I'm going to trust this because I did it and I know it gets there. So if there are 5 cases you could cite, one's from Iowa, one's from California, and one's written by the judge you're in front of, always pick the third. It's just, because we know our own work, we know the quality of our work. If I'm reading an opinion of a judge I don't know well, and frankly, in Social Security, I literally in the First Circuit region, I know the judges and I know the ones who write opinions that I think are really good. And I like mine. So cite me back to me. It's very frustrating when I get a cite to, like Northern District of Idaho, and I say, I wrote something on this about 6 months ago. And this Idaho thing doesn't make any sense. And I don't think it's the First Circuit standard. So do I have to stop and now find my own case? Why didn't this lawyer give me my case? That doesn't make sense. So that's a shorter is better. That said, there are some.
Wait a minute, can I underscore that? A voice of God. What did you say? You said long. You must have said longer is better, because that seems to be everyone's thought process.
No, shorter is better.
It really is. I know you say that, and I know it's a lot harder to write shorter.
Oh, it's hard to write shorter.
Yeah, I'm
Yeah.
sorry. Go
Yes,
ahead.
yeah. Shorter.
I'll be quiet now.
Honest to God, shorter is really better. But, and this is important, as we all know, failure to develop the argument, you may get one of those little footnotes that says this argument was waived, failure to develop. So nothing is also not good. So a bland statement, the ALJ made a vague error with nothing that tells me what the error is and how that error is reflected in the record, is very likely to draw a footnote that says failure to develop the argument means the argument's waived, and we'll do that. But once you articulate it, tight, short, clear, cite the record, stop.
Yeah, I agree with a lot of what you're saying, Judge Sullivan, and I also agree with Judge McConnell's point on shorter is better. And to be candid with you, I've looked at some rules that apply in other districts around the country, and I know there are some districts that have page limits. And when I was first a magistrate judge here, we had page limits generally in civil cases, which I don't think anybody wants to go back to that world, but self-imposed page limits might be something you could strive for. Man, I think when Judge Sullivan talked about the statement of the issues, I think a good structure of a brief is starting out and just in plain terms telling us what are the errors that the ALJ committed, then deal with each of those errors in a separate section, and then in the end summarize and reiterate what you want us to find in detail and lead us through it that way. I think that's a helpful structure of a plaintiff's brief, and then it allows the commissioner to respond with a brief that has an argument section that responds to each of the argument sections brought up by the other side, and it allows us to compare those and understand what the ultimate issues are. I would also say, I don't know where I heard this term, but I did hear it somewhere over the years when I went to some CLE on brief writing or advocacy, and it stuck with me. But the concept, hunt with a rifle, not a shotgun. And we get too many briefs where we have 4, 5, 6 arguments of different errors that require reversal and remand. And frankly, I think that kind of approach undercuts the credibility, because as somebody who's then reviewing that brief, you'd think you've got your best argument, you should lead with that, and maybe you have an alternative argument. But if you're not going to win on those and you're presenting 6 or 7 arguments to us, which we do get on occasion, then it kind of puts you in this position where puts us in the position of wondering, is there any good argument? Because why are there so many? I remember once I had to argue a case before the First Circuit Court of Appeals, and I think at the time we got 10 or 15 minutes per side to argue. And one of the attorneys on the panel that was arguing a different case made an oral request for additional time. And I can't remember which judge it was in the First Circuit, but they denied the request and said, if you can't tell us in 10 minutes why this case needs to be reversed, then you can't tell us at all. So I think that same principle applies here. The cases that we do reverse, it often is pretty easy to explain why there was an error, to see it. And 50-page briefs and 30-page reply briefs aren't necessary. And again, they only make us wonder, is there really an argument there, or is there an attempt to throw a lot against the wall and see if something sticks? So I really think concise briefs on both sides are what's most effective in this context.
Can I just add my 2 cents with, because as some of you know, I occasionally keep Social Security cases. Just 2 points on that. I do it because a very learned judge out in the Midwest once said to me when I was in baby judge school, you should keep, as a district judge, you should keep some Social Security cases, because you should understand the system in a way so that when you're reviewing reports and recommendations, you get it. And so I've tried to do that. I do it 100% indiscriminately. When my case manager says, do you want to refer this or not? I look at I keep a pending list of my current work. And if I feel like I can handle it and give it the time it's due, I say, sure, I'll keep it or not. I don't know who's involved. I don't know what the issues are. It's totally and completely indiscriminate. It's based on my workload. And whether we just had a judges meeting where Judges Almond and Sullivan complain about all of their work and I feel guilty. So it's those two balances that make me take a case or not. Two points that I'd like to make on the briefs that I picked up. I would find it incredibly helpful if, let's begin with the claimant. If the claimant in a page or so told me what their case was explicitly, and I don't mean in general terms, I mean, the ALJ made an error, here's the error it made, and here's why it's material. And if you have a second or third one, I'm with Judge Allman. If I don't find error in the first two or three, the likelihood I'm going to find error in the final ones it just doesn't happen, particularly given the standard of review. But if you could begin every brief right away, setting the tone and telling me what it is that you think is such that it should be reversed. So when I read all of the things, I've got my head focused on it, right? And then I know what you think is important and I know what perspective you want me to have. That's from the plaintiff's point of view, who defines the contours of the case. And specifically with the commissioner, and I actually find the commissioner does a better job at this, but I also recommend something short and whatever upfront, saying they claim this error, that's not an error, here's why. And just give me right up front, so when I read your brief, my head is in your head in a logical way. I don't know if that's true with with the magistrate judges. I would find that very effective, because maybe you don't know this. None of us have ever practiced Social Security law. You may not realize it. You guys speak Greek. It's not law you speak. It's not English you speak. You speak Greek. You get it. I've been to your conferences. I've heard you. You speak Greek to each other. You get it. I don't get it. I think maybe Judge Alman and Sullivan get it by now, but I do not enough that I don't get it. So my second piece of advice to you is talk normal. And I even mean, let me just give you a little example. And I know by now I should in my head understand what a state agency expert is. I should have that down, but I don't. Does that mean someone that the government hired? Is that a neutral person? Is that a plaintiff? I don't know. And so it's just one example to say, if you talked normal speak, now you may have forgotten normal speak in your world, but if you could translate, at least for my cases, your language into language that fits the legal paradigm in a way, I would find that far more effective from both ends. That's the second one's a little quirky to me, because I don't do that often. And I know that magistrate judges have kind of the system down. But the first one I think is important across the board. If you could in one page, limit yourself to one page, right at the beginning, set the stage, tell me what to look for in a real distinct way, I sure would appreciate it. And I think both sides would be, well, that's the plaintiff side. I think the commissioner responding exactly to it in a short, concise way. So when I read your brief, I know what's important and what's not going forward. Anyway, that's my 2 cents worth for the little bit that I do.
Should we open it up to some questions at this point? I don't know if Nora, you can spot any questions for us if people raise their hands electronically or otherwise. Questions or comments or suggestions for that matter. Mr. Nagelberg, it looks like he has a question.
Thank you, Judge Allman. I just wanted to make a comment about something that you and Judge Sullivan were asking about, the in-person oral argument, if we return to that. And I do think I can speak on behalf of my colleagues at the agency that it would be helpful to have a virtual remote option. We do have some employees, myself included, who live in the Rhode Island area. We're actually in Rhode Island, but the majority do live farther away. And so it would be an increased efficiency for my office if they continue to have that option to participate remotely, even after the courthouse reopens fully.
That's good to hear.
Yeah, that is good to hear. The case I had recently where I did have oral argument on a consent case, the plaintiff's attorney was, oh God, what's the name of the place? His office was near where the groundhog comes out in Pennsylvania. And so we had a nice little chat about Groundhog Day, and it was right around Groundhog Day. But I think it was a little more convenient for him to do it remotely than to come from the middle of nowhere, Pennsylvania, to Little Rhode Island. Any other questions or comments or suggestions?
Mr. McGuire.
I'm going to try to be brave here. I mean, on the oral arguments by video, I only had one recently with Judge Allman, and it was terrific. I see the real value in that from, although I like to get out of my office and see people, which you don't get to do anymore. I found that to be a very valuable thing to do. On the consent issue, I'll be the groundhog and stick my head out of the hole at the moment. I mean, no offense by not consenting to the magistrate jurisdiction, but I was advised a million years ago when I did my first few briefs that you never consent because of, now you propose that you get a second bite at the apple by having an oral argument. Well, it's a second bite at the apple in the district court that we get here, and you can't ever just give that up. And part of the reason is that the next step, the First Circuit, is really inaccessible. I have only tried twice in my whole time, and it costs a fortune to do it because you have to hire somebody who knows what they're doing there to take you through the process and all that other stuff. And while I very much value the magistrate opinions, sometimes you want to have a chance to disagree without going broke doing it. So on a practical end, that's a very difficult thing. And the other thing is that, if in a regular year, you get about 90 of these cases, 45 apiece to the two of you doesn't seem fair to anybody.
It borders on impossible because every case has to be written.
Right. So it doesn't. So, I mean, I like having occasionally Judge Smith deal with a case or Judge McConnell deal with a case because it's a fresh person looking at a case where we are all human. And, these cases, a lot of them are similar in terms of the mistakes that we claim were made. So I don't know. It's a difficult thing to give that up from a practitioner's point of view. I don't know if other people feel the same way.
Well, I respect that, Mr. McGuire, and we, of course, understand that. We were all litigators, so we understand that's the reason. My point was simply the small number of report and recommendations that have been, I'll use the word flipped by a district judge over my 17 years. I think I could count them on one hand or less. And the cases where I've held oral argument and I've gone on the bench either with the intention of ruling for the claimant or for the commissioner, and I've had an advocate persuade me in that oral argument to go the other direction, has, I think, happened on a much more frequent occasion than the times that my decisions have been reversed by a district judge. So you could take that for what it's worth. And if we don't get consents, that's fine. Most of my career, we haven't gotten consents, and that's just part of my job. I'll deal with them. But I'm being candid with you that I think it is a lost opportunity, because in a case where I have to write a report and recommendation to a district judge, and I know I'm going to have to go through that formal process and write that decision, I probably won't invest the additional time in preparing for and holding a Zoom hearing. So that is a lost opportunity to advocate. And, just as you don't want to give up that opportunity to that bite at the apple to object to the district judge, which I understand. I'm also saying, as somebody who's managing my caseload, that I'm probably not going to have oral arguments in many cases now that aren't consented. Now, I had one in a case with you recently where it was not a consent case because there was an issue that I wanted to hear from you on, and I didn't want to spend time and money on more briefing. And I actually think it worked tremendous. I don't frankly recall if you won that case or lost that case. It doesn't really matter. But I do, the process, having that argument was helpful to me to understand the issue in question. So, and I may do that on non-consent cases from time to time, but the overwhelming majority of them, I'll just deal with them on the papers is what I'm going to be forced to do because of the demands of our workloads.
Mr. George?
Yes, thank you. And Your Honors, we're discussing in terms of, in terms of sort of the benefits of filing concise briefs. And I know one question that we've been thinking about here, at least from the commissioner's level, is in terms of a fact section in the briefs. And I know that we typically do include a fact section, but I know that there are other jurisdictions, for example, particularly where the ALJ may have provided a robust fact section where we will, refer to the fact section or rely on what the ALJ stated rather than restating a whole fact section. And then through the course of the brief, referring to facts intermixed with the argument. So I was wondering, Your Honors, in terms of what your view is and what's, what your preference would be.
That's a great question. I don't know what my colleagues are going to say. I do not typically spend a ton of time on the fact section that's appearing in the briefs. And what I really want to see is an issue, an error, and now you're responding to the error, and a built out factual discussion of why the error was not error, how the evidence reflected it. I actually had a brief from the commissioner's side within the past year. Luckily, my brain does not recall who was the attorney, what was the case, but I remember there was a bullet point summary with citations, and they were all accurate, to the evidence that added up to, yes, the ALJ did have substantial evidence. Here's what it is. Bing, bing. And it was done in a very concise bullet point fashion. And I literally copied that page of the brief as I was writing my opinion because it was so helpful. So I find that helpful. And I don't find a tedious, in January, she went to this doctor, and in February, she saw the psychologist, and in March, she went to the emergency room. I think the ALJ generally does that pretty nicely. Every once in a while, that is the gravamen of what's in issue. What was the sequence of treatment? But in a lot of cases, it's really not. And then it's just wasted pages and probably a lot of wasted work for both sides.
I'd agree with that. And I think just identifying the facts that are material to the arguments is most important. Some of those long summaries of the facts in a case, when I go through them, once I get to the arguments, I realize that most of them really aren't even relevant. You know, it's particular opinion or a particular medical record or something that is really critical, and it's a waste of time to spend on all the facts. And if the ALJ has accurately laid out the facts and the only issue is how the ALJ has weighed and analyzed that evidence, then just referring back to the ALJ's decision is sufficient, because we can read that and we read it anyway.
Just briefly, I'd underscore that. Will let you in on my little secret of how I do it is I read the first page or so of the plaintiff's brief to figure, I just want to know who we dealing with here and what have they got, and, you know, where they used to work and what's their, and, you know, figure out who the human being is. And then I skip, and it's usually all the way to like page 17 where the legal argument appears for the first time. I don't know that I've ever read a fact section. For the very reason, Mr. George, you bring up, it's repetitive. Maybe I'm a little more reliant on the ALJ earlier on opinion than Judge Sullivan, but you know, I know it's a lot of cut and paste, I get it, but going through, like Judge Sullivan said, this happened on this date and then they went here, most of the time that's not relevant. Rarely is that relevant. When it is, I get it. Most of the time, it's not relevant at all. So I have found fact sections completely and totally useless and jump right ahead to it. And then when facts are referenced in the legal argument, I go back to the ALJ, because rarely have I ever seen an argument that the ALJ got a fact wrong, you know, a chronological fact wrong. You know, if that is the problem, then it's important. But
it does happen, though. There are some cases where the error is the ALJ has misconstrued the record in some way that creates a harmful error. But any other questions or comments? Yes.
Let me unmute. You know, I want to thank you all for having this session, and wanted to let you all know that we actually, we used to, before COVID, we would meet 4 times a year as a Social Security subcommittee, if you will, of the bar. And although we did not do that during COVID, we actually are hoping to have a Zoom meeting next week. And so if there are these types of issues or something that might come up, there would be a way either for one of you to, you know, either by Zoom. I think we've all realized how efficient Zoom can be in terms of not wasting time. But if you wanted to address our committee or get something across to us, there is that mechanism, you know, again, normally, and I think we will be back on track with the quarterly meetings. But with, you know, given the, you know, substance of what was just said, since we are meeting next week, you know, those of us who are on here as practitioners, we can both discuss and further disseminate the lack of a need for a fact section, because, you know, as someone who writes these briefs, sometimes, you know, going back all through that, and I think we all thought that sort of a good, well-written district court brief would have this long recitation of facts. So I, for one, am happy to know that you don't really need that. And, you know, I'll try to disseminate and in future briefs, just, you know, say that at the direction of the district court in general, you know, a further recitation of the facts is omitted, except for perhaps whatever ones like you know, someone just said that might be relevant to the actual argument. So I think we would probably, those of us who write these briefs would welcome the, you know, the lack of the need to go through all of that. And I kind of wanted to chime in on the whether you consent or not consent to the magistrate having the final. And I think Steve is right on in terms of, number one, it is really difficult to go to the First Circuit, but, you know, that's the world that we live in. But I think for me, the other thing that often happens when you hear from the other side is it just sort of further gets into the actual arguments. And there's just sort of an evolution of the case. And I'll be honest, you know, I learn more about the facts and the law and my arguments when I read the commissioner's defense of theirs. You know, it makes me either dig my heels in on something, or perhaps sometimes the commissioner will point out an authority that I go then and read and realize that, you know, reading further on in the decision or in the sentence is actually helpful to me. So I can understand why it, you know, may be repetitive and may not be the most expedient way, so to speak. As I said, I find I learn more about the actual case and the law and my own arguments as the process sort of unfolds. So I don't know if it's a necessary evil, so to speak, to just have it, that little tennis match of back and forth. And I guess we can all just hope that in the end, it gets everything anyone might have to say, again, that's relevant to an actual legal argument out there. And, you know, then let the chips fall where they may. But I know I too am reluctant to consent just because I want to hear what the commissioner's defense might be. And it just kind of goes that way. But thank you so much, all of you, for your service, not only to our Social Security claimants, but I think, you know, we all know how much you do for everybody in Rhode Island and all the litigants. So thanks.
Any other questions? We have just a few more minutes.
Mr. Boland?
Yes, thank you. I was wondering, Your Honors, if you could comment very briefly. I know you each mentioned some arguments that you found not terribly persuasive, or maybe more in lines of pet peeves seeing in certain briefs from the claimant's perspective. If you might have a few that you found from the commissioner's arguments time and again that perhaps were not terribly persuasive or more in line with something of a pet peeve of yours to read in a brief.
I mean, I haven't had this come up in a long time, but there was a point in time where I did, I think I had to contact the U.S. Attorney's Office. This is years and years ago, because some of the briefs I was getting from the commissioner were not matching the arguments in the claimant's briefs. So I don't think that's the case anymore, but I think I don't want to speak for Judge Sullivan and Judge McConnell, but if a claimant makes arguments A, B, and C, then I want to see a brief that has a response to A, a response to B, a response to C. There was a point in time where we were getting some briefs that had more generalized arguments or different section headings in an attempt to argue for affirmance of the commissioner's decision, which then didn't allow me to do an apples to apples on each issue in the case. And that hasn't happened, but that's helpful. And this isn't a pet peeve, but I think Judge Sullivan brought up somebody in your office had done these, because I saw one as well, where there were bullet points of the substantial evidence in the record with citations supporting a particular finding of the ALJ. And it was very helpful, actually, because then you could just go through and check those sites, and it was all clearly laid out. Here's the substantial evidence. Here are the 5 pieces of evidence that support this conclusion, and here's the record citation. That's.
Yeah, I have one pet peeve that and it's when the commissioner's brief leads with a technical reason why the ALJ should be affirmed. A waiver, a failure to develop the argument wasn't mentioned in front of the ALJ. And I every once in a while, like 1 in 100, that is the lead argument, and it's the best argument, and it may be the only argument, because there's really nothing to be said. But we're very conscious, I mean, I think you've heard this a lot, of the importance of these cases and the claimants. We're conscious of the, sort of the overarching theme of interpret the Social Security Act with liberality and all of that. So if the claimant has presented a serious error and a sympathetic case, and an error that's consequential, so that someone who might very well be disabled has been found not disabled because somebody screwed up, it just doesn't feel right to be reading for technical reasons stop here and reject this. So I get annoyed every time I see that as a lead argument in the commissioner's brief. And usually that might be paragraph 1, and then paragraph 2 is, all right, now I'll turn to the merits. I would say flip that. Go to the merits first. And then if you think there's a technical argument that's worth considering, yeah, make it. But I am really disinclined to look for technical off-ramps to make easy decisions if I've got a claimant with a real error that's consequential.
Thank you.
All right, looks like we're at 5 o'clock, so we're out of time. Thanks everybody for attending. I was actually afraid nobody would show up. So thank God somebody showed up.
Yeah. And by the way, Ms. Nesselbush, if you want, like, 6 months from now, one of us to come and speak to your group, I, for one, would be happy to do that, especially if it's by Zoom.
Thank you so much. I think in years past, we had that, but again, everything sort of has been derailed by COVID. So hopefully we can get back on track and do so in an efficient Zoom manner and make sure that we have just that good communication between the, bench and bar. So thank you again.
Yeah, thank you all for attending.
Yeah.
Make sure you look in the chat section for those that want CLE and email Raina. So don't leave until you read the chat if you're going to look for CLE for this conference.